Commission meeting to order. First thing we need is approval of agenda.
I make the motion, we approve it.
Second,
A second.
all those in favor?
Aye.
Okay, we need to approve the minutes, which includes our regular meeting and the hearing, right? Or separately or together?
Either way.
Okay, I need approval of the minutes for the regular meeting and the hearing that we had.
Motion to approve.
Second,
Yeah, I'll second.
so approved.
Oh, just need a vote on that one. You have a motion and a second, you just
Kind of
need a
skipped
vote
that,
on that.
didn't I? All those in favor?
Aye.
All right. Okay, public with business. Now, we vote on this, or is that,
This is only if anybody has signed up to speak to the commission, and I do not believe anybody
Okay.
has signed up, so this one we will not have anything for.
okay.
Was there even a pad of paper there?
Yes.
Oh, okay, I didn't notice.
It's disappearing ink.
Yeah,
Okay, new business, civil service rules and regulations. Anybody want to read them? Or any questions, I guess?
So why don't, if you'll give me the floor here, we'll go through a presentation and then talk
okay.
about kind of next steps and walk you
Oh.
through it, so.
That's
You've
right.
you've asked for a little bit longer of a meeting. Jerry always likes to be here in Ernest Keep, so.
there you go.
Here we are. All right, so just kind of briefly tell you what we're going to review as to the updates to sections 3 and 4 that you have before you. We're going to talk about Iowa Code Chapter 400, just a brief overview of that, and then why we're here with these rule updates, Senate File 311. We're going to walk through each one of the proposed rule updates, and we're going to talk about a request to suspend Rule 1.5 to amend the rules. And then I'll have a slide to kind of walk you through what our request is today for next steps. And then, of course, we'll have time for discussion and questions from the commission. Okay, so you all are familiar with the civil service law. This is Iowa Code Chapter 400. This establishes hiring and other employment procedures for certain Iowa cities. Davenport is included in one of those cities. And it covers permanent full-time positions here at the city, not part-time positions, not seasonal, only full-time employees. There are exceptions outlined in Chapter 400 for department heads and other administrative employees, but I'll tell you the majority of city employees here at Davenport are covered by civil service. So that's the law that we follow here for the Civil Service Commission. Senate File 311 was brought up in the 2025 legislative session at the state. It modifies certain provisions and related procedures for Iowa Code Chapter 400. So we have the existing code. This legislation modifies that Chapter 400. It was passed, like I said, in the 2025 legislative session and signed into law by Governor Reynolds back in May. The effective date is August 16th, which will be important when we talk later about today's August 13th, so we're going to be requesting that you vote to approve them effective August 16th to align with that piece of legislation. Any questions so far? Okay. So the rule updates we have before you, you can see the list here. It's 3.3, 3.4, 3.5, 3.6, 3.8, 4.1, and 4.2. So we're going to take those one at a time and just make sure you don't have any questions. Concerns, anything like that. Most of these, I will say, and I'm going to get to my next slide, most of these are compliance with that Senate File 311. We did take a holistic approach to this and make sure that there weren't, of the ones we were reviewing, if there were other things that needed to be changed at the same time, and we'll point those out to you. We just thought it would be better to just change them all at once rather than having to bring other changes back for these particular rules. Okay, so we will get started with the first rule, and Andrea is going to take this one.
Okay, so in front of all of you today, you should have a packet with all of these proposed updates. So I'm kicking us off with Rule 3.3 that's in front of you, which handles subpoenas. So you'll see this top half section here outlined in red line. This goes over updates to the process for subpoenas. And then the second section, kind of the second half of that rule there, adds new language regarding the reproduction of other employees' disciplinary records. So one of the changes that we saw in Senate File 311 was the commission's requirement to ensure that discipline is proportionate reasonable, and just. And this update to the rule provides you all an avenue to do so. I will note too, we had a scrivener's error 2 lines up from the bottom there. It at first said it was chapter 400.71, subsection 1, paragraph B. It should be 400.27. Any questions?
What's the, what's the change?
So anything that you see in red lines on this rule are changes that we've made. So that first section, we added quite a bit of language to go over the process for obtaining a subpoena. And then that second section, again, we've added language there. So we're not getting rid of language or updating, we're more so adding language to ensure that we're in line with our requirements from the state.
So this is more administrative for what you do than what we do.
Exactly, yep.
Okay.
Okay, our next update is going to be to Rule 3.4, which it goes over the rules for appeal proceedings. So you all will see towards the middle there, you've got an added language detailing the professional expectations of counsel for both parties during appeal proceedings. So Allison mentioned a couple of slides ago that we weren't just reviewing for state of Iowa updates. We were also going over best practices and that sort of thing. In reviewing, we wanted to ensure that we included language to kind of drive that process. So you'll see that update. And then on the bottom there, starting with that sentence that says the final written decision of the commission shall. This is language pulled straight from that Senate File 311 update. So they have added expectations on how your written decisions are made and delivered.
In there, it says abusive conduct by attorneys or witnesses. Who's to determine that?
I would say the commission with the assistance of your legal counsel. This hasn't been an issue, certainly. Sometimes we can get a little heated or, I don't want to say it's walking towards combative, but I think if you all feel like it's crossing a line, if your attorney advises you, and he's sitting right here, if he advises you, hey, we're getting too far, I think it would just be an individualized assessment.
So we could just say, they're getting out of line. Mm-hmm. Then the other one would be, final written decision should be based, well, whatever, like, it should be in conclusion. If we did something that didn't make somebody objected to, what's the alternative? Is there an alternative? I didn't see it.
Are you asking, are there
Like there is,
appeal?
like it says it's supposed to be findings and facts, conclusion of law. If somebody else says, well, this isn't the law, you found it on some other grounds.
So I would say two things to that. Number one is that your attorney is reviewing this and assisting you with drafting the written decision. So this isn't something that you all would have to come up with. I mean, I think the attorney would help you do this. The second thing is if someone disagrees with your findings in your written decision, they can appeal to district court.
Okay.
Any other questions on this one? All right, let's move on to 3.5. Thank you, Andrea. Let's see, so you'll see a few different updates to 3.5. First off, we deleted the current paragraph E. This one was duplicative. There's there's some language in Rule 3.3 that addresses this, so we didn't want to have it twice. But that gave us an opportunity to add in a new paragraph E dealing with exculpatory evidence. And I don't know about you, but in your day-to-day lives, you probably don't deal with exculpatory evidence. So I've asked Attorney Huff to just kind of give you a brief definition of what that means.
So exculpatory evidence is evidence that tends to, in this context, tends to show that an employee didn't break the rule, right? Or tends to show that the rule wasn't clear or fairly applied. So, was the clear instruction given? Was the rule clear? Did the employee honestly could understand what they were being asked to do? And then, or it's evidence that could show that the punishment is too harsh for what actually happened. So think, how was this handled, and how was this kind of same series of events handled in a different situation or with a different employee? If the two punishments don't line up, were there extenuating circumstances that justify that or not? But exculpatory evidence in that standpoint is the evidence that, hey, this employee was treated this way for the same or similar act than this employee. So that's kind of how exculpatory evidence works in the civil service appeal hearing process. And just so you're aware, right, this is more of a stipulation on the city that any evidence that tends to be exculpatory must be given to the other side. Not that that was being withheld in the past, but it's just been codified with the state law change, and so now it's just part of the rule. So again, this is more grounds for the aggrieved party or the employee to say they didn't turn over what they were supposed to, and if you find that that's appropriate, then that's a grounds for modifying the punishment or canceling the punishment. So.
Could I ask another example too?
Yep.
So if let's say the person appealing their discipline asks for their personnel file and all of their performance evaluations, and they have 20 years of glowing performance evaluations, and the city withholds that from them, could that be a violation of this?
Yes, that could be exculpatory evidence. Someone's performance record over time is part of the totality of circumstances that the state has determined they want civil service commissioners to look at. So if you have an exemplary employee, that should be evidence that, one, that they should be able to present if they choose, and two, that if they don't have access to it by regular means, that it should be provided by the city to them, right? So not everybody keeps their own file of their accolades or awards or whatever. The city does in most cases, if it's requested, and even if it's not, should be turned over. Because it could be exculpatory in determining whether the punishment was justified.
Does that make sense?
I'm also preparing some, what I would call cheat sheets. I'm trying to keep them to one page, but kind of goes a little more in detail on just this and common examples we might experience in these hearings.
So this would have to be details and people, not just like we hear, oh, everybody does it type thing.
Yeah, so typically exculpatory evidence is fairly specific, right? So a good example of exculpatory evidence is the charges and specifications say that on this day, at this time, the employee was doing X, and there's actually a video that shows the employee is not there at that time and date, and therefore cannot possibly have committed the act that they're being punished for, right? So that's the exculpatory. The reverse of exculpatory is called inculpatory, or just evidence of the act. And that would be if there's a video that clearly shows the employee doing the behavior or whatnot that they're accused of. So.
Again, Sam mentioned this, or Attorney Huff mentioned this. This isn't a known issue. This is just coming from this Senate File 311. So, but we wanted to bring it to your attention and include it in the rule.
And just for your awareness, my policy kind of on this is we have an open file policy. So if the other side says, hey, what do you have? We just say, here's what we have, right? We're not making, the attorneys in my office are not making judgment calls as to the exculpable nature or the innocence nature of the evidence, right? That's for you to determine whether or not you believe the evidence tends to lean one way or the other. So our practice will be, if they request certain things, that it's turned over. So hopefully this will not ever be an issue.
Yep, agreed. Okay. Moving along with, staying with Rule 3.5, there's also a section discussing the production of evidence. So Senate File 311 talked about that the commission shall provide for the production of evidence and exchange of exhibits in advance of trial. So Attorney Huff here advised us what that means is that the commission has to make rules for the production of evidence. So the rule before you, 3.5, the draft, we are recommending that it's at least 5 working days in advance of the hearing. So that would be the commission's rule for the city's attorney representing, and then the appellant's attorney would have to exchange exhibits in that fashion. Additionally, there's language that outlines how the exhibits will be marked. The cities will be with numbers and the appellants with letters. So that's just some clarification to make sure everybody's following the same book of music. So if you all are comfortable with that, again, we're not voting yet, but that's our recommendation. If you feel differently, we can certainly take that approach as well. Any questions, additional questions on 3.5? Okay.
So I just want to add to this, so like, maybe in your minds, why do I care when they turn over evidence, or why do I care when exhibits are exchanged? Sometimes in kind of a courtroom setting, if you don't meet those deadlines, it's justification for the other side if they say, hey, we need more time to review this evidence, or in the, I guess, worst situation, the evidence that's not been turned over is not actually available for use at the case. So if the city doesn't turn over an exhibit within the prescribed time, it's precluded or excluded from being able to be considered. So that's why this rule exists in general, and that's how someone may want to apply it in a civil service appeal hearing situation.
It's only 5 days typical.
So this is not meant to be, this is meant to be an ongoing process up until, but 5 days is generally, so that somebody has chance to review all of the exhibits, because sometimes exhibits are not always fully determined at the time, right? There may be video that hasn't been obtained yet, or that needs to still be obtained at the time, maybe charges and specifications are turned over and stuff like that. So this is just meant to be like a hard stop of like, if it's not been produced at this time, don't count on being able to use it. It's not meant to hold everything till 5 days out, or at least that's not how I will instruct the attorneys in my office to apply it. It'll be an ongoing thing as you get it, turn it over, but make sure that, you know, by the 5th day, everything's labeled, and that's so the other side can know what's going to be presented both ways, and if there are objectionable materials, those sides can hammer that out, hopefully, before the hearing, if necessary.
So if something suddenly is discovered less than 5 days before the hearing, it's not usable, or you'd have to postpone the hearing?
So that would be something that the commission would be asked to decide, and obviously I would be here to advise you. My, I guess, just guidance without the specific fact scenario is, if there's a valid reason why the evidence could not have been turned over within before the 5-day time limit, then it's probably justification for a continuation of the hearing, or the use over the objection to it. And then if it's something so material that they feel like their rights were, you know, not upheld, then they can appeal to the district court. But generally speaking, what happens in situations like that, a continuance is requested, and it's granted to allow that time. And sometimes it can be a continuance to say, hey, you know, this is a piece of paper, you have the next, you know, we're gonna just go in recess for 2 hours, review it so that you understand it, and then we can move forward. So many different ways. Again, it's very fact specific, and hopefully this doesn't happen, but it's something courts deal with all the time, attorneys deal with all the time, so we will work through it.
Just one more question on this. Is either party able to produce evidence as a rebuttal to testimony at the hearing?
Yes, generally what's known as rebuttal evidence does not follow H, the rule of H, because you don't know what the other side's necessarily presenting at trial. What H is supposed to prevent is quote unquote like sandbagging, basically like trial by surprise. And so if in fact testimony is presented by either side at trial that wasn't necessarily relevant or anyone's radar before trial, then certainly rebuttal is part of that. So typically doesn't happen too often, but it can occur. But rebuttal evidence generally is evidence of such a nature that no side was looking to produce it until certain testimony or certain other evidence was put in, so.
Any other questions on this one? All right. We'll move on to Rule 3.6. This one's called Public Trial/Media. One significant change that has been discussed by this commission in years past is that now, upon the request of the employee, deliberations can be held by the commission in a closed session. So currently, when you are considering, you have a hearing, you're considering whether the employee's discipline should be affirmed, modified, or overturned. That discussion is an open session, so you're talking about the person while they're sitting in front of you. Now, if the employee requests it, the commission can go into closed executive session and discuss it kind of behind the scenes. So that's a change under the law, and so we've included it here in your rule.
The purpose of this law change was the protection of employees. So, you discussing whether you find them credible, not credible, things like that. The states felt that in situations like this, that could be more damaging to have an open session. If the employee wishes it, they can request it. So, and it would just be by motion, right? So if the employee makes it, there would be a motion to close session at that point. Everyone would be excused. We'd have a closed session, and we'd come back and deliver the decision back in open session.
So you'd come out of closed session, and then someone would, similar to what you do now, someone would make a motion to affirm, modify, or overturn the city's decision to discipline. That would be an open session, and you'd all individually vote, just like you do now. Make sense?
So it's only the employee, the commission couldn't ask it, or the prosecution couldn't ask it.
Correct. It's at the request of the employee.
All right,
All right, let's go on to Rule 3.8, currently called non-lawyer representation. So this one is actually, in doing our holistic review, the current law in Iowa Code Chapter 400.18 allows for employees to be represented either by legal counsel or by their union representative. This was something we weren't aware of previously, so we are requesting that you update this rule to reflect the current law. We'd also ask that you change the title from non-lawyer representation to just representation. Any questions on that one?
so a person couldn't have a friend present their case,
No.
either
So
a lawyer or the union.
either the lawyer or the union representative. That's it. Those are the two by state law.
Now, the union representative doesn't have to necessarily be an attorney.
Correct.
And they typically are not. If it's a local union representative, it's another employee who may be familiar with the case, the employee, the situation, the equipment, anything like that. So the authorized union representative would be able to provide representation if the employee chose to do so. Okay. All right, moving on to Rule 4.1, legal counsel. This just outlines who can represent you. So there is, you can see here, it's outlined that the city's corporation counsel, which is Attorney Huff here, or designee, unless there's a conflict of interest, as outlined in Iowa Code Chapter 400. I'm not going to read through all of this for you. You can obviously see it. If there was a conflict of interest, the commission could hire outside legal counsel to do so. I just want to note, and Sam, feel free to jump in here. There is a separation. You've noticed that Attorney Schulte, Attorney Behan were the ones presenting the city's case. Attorney Huff was separated. He was your attorney, so he was not jumping in and questioning witnesses and things like that. So that separation has been maintained, so that we're not in any conflicts there. So, anything else you want to add?
Yeah, in the background, so like things that occur outside of this hearing. So to make sure that this is above board, we've created what's called an ethical wall in my office. So when it comes to the representation of city at the civil service level, I have nothing to do with that. I am not making a decision about the charges and specifications. I am not reviewing that. I am not being necessarily informed of anything that's going on from the representation of the city. So that's a completely separate. Even though they're employees within my office, we do not discuss those cases. They do not ask for my advice. They do not ask for my counsel. I do not direct them to do this or that. So there's that clear delineation of those things, so that because what the state law has also done is at any point, if I've represented you, I'm also precluded from representing the city. So like it goes both ways. So it's essentially, if I was to represent the city at some point, I could not represent you. And because I've already given guidance to you, not just in the civil service appeal hearing setting, but in other settings, I'm actually precluded from representing the city to kind of create that. So again, if conflicts of interest do arise, we will obviously make you aware of them and let you know how independent counsel will be attained for you to guide as those come up. Like if, because I could have a conflict, like I don't have a relative who works for the city, but if there's a relative who's being disciplined, I would not want to be part of that, right? So those types of conflicts of interest, we would be issue spotting and bringing on outside counsel for those.
And you would be making the selection for outside counsel, but to clarify, the city would be paying for it. You're not on the hook to pay for any of that, so.
In the past, year or so ago, we would have an outside counsel. Now we have the city attorney. Obviously, that, it changed.
There have been, I can recall one instance off the top of my head where the commission hired outside counsel for a hearing. But previous to that, it was the city attorney's office representing you, and as well as the city. So now that this law is in place, or will be in place August 16th, like Sam was talking about, there's that clear delineation, so.
Okay.
But if there was a conflict of interest as outlined in the law, then the commission could hire outside legal counsel.
And again, that can be a decision that, if any of you have questions about that, right, then you're free to ask me those questions and I can tell you, here's what conflicts are, here's what I see. I would obviously have an ethical duty to notify you of conflicts if I know of them. So, but again, if this is a question that comes up, we can address it and make sure that, because I don't want to create appeal issues any more than anyone else, so.
All right. Last but not least here, Rule 4.2 regarding legal opinions. So in general, legal opinions are provided by an attorney to the client. So that would, you all, the commission, would be the client. Legal opinions are typically not publicly shared. If Attorney Huff is providing me with a legal opinion, that's not something that I would publicly share with others. Right now, Rule 4.2 states that legal opinions will be publicly shared. So staff's recommendation is that we update that is not publicly shared. This is not something that's required by Senate File 311. This was just part of our holistic review of some of these different rules. So that's just a recommendation from staff that if your attorney is providing you with a legal opinion, it is attorney-client privileged. Make sense? Okay.
Now, if we have a hearing, like, let's say like last time, and the, what's the proper word, claimant or whatever, their side disagrees with our order, our final opinion, is there anything to continue, or what would happen?
Under this law, they can go to district court and have another full-blown
Okay.
hearing.
We haven't had it happen, but I wondered,
Not since I've been here, no.
okay.
Actually, I take that back. It has happened once. Yep. It has happened once. The district court did not rule in favor of the appellant.
And that's common for any, what we call administrative hearing process. So, there are other boards and commissions the city has that hear appeals of other city actions, and this just kind of goes in line with that. It actually gives the employee more rights than in other administrative hearing situations. So again, employee protection here gives them kind of the whole access to a whole new trial setting if they completely disagree with the way the commission ruled.
All right. So the next agenda item is to discuss your current Rule 1.5. We're not proposing to change this one. This rule requires discussion at 2 regularly scheduled meetings. You can see the text from Rule 1.5 there. With this legislation going into effect August 1st, we would be asking you to.
16th.
I'm sorry, August 16th. Thank you. We are asking that you would suspend Rule 1.5 in order to make them effective and just have the vote at 1 meeting instead of 2. That's what we're asking for. So as you know, I announced these upcoming revisions to you at the last meeting in July. You were provided electronic copies August 5th and August 7th, so you had time to review in advance. So again, just requesting before you could vote to update the proposed rules or proposed rule changes, that you would suspend Rule 1.5. Okay,
For this one time or permanently?
for this one time. Mhm. And actually, later on in the agenda, we're looking at another rule change that we've already discussed, so you can see we're following the normal procedure for that one. This is the one. I will tell you, and Attorney Huff can attest to this too, this has been a very significant undertaking. HR and legal have collaborated quite a bit on this. Legislation is not always the easiest for implementation at the local level at times, so this has been a long time coming. So this one took much longer than other rule updates have. So that's why kind of asking you at this meeting to make sure we got it all right and had legal's blessing as well.
And I would just advise you that if you feel that you do not want to suspend the rules and you want to just follow through, the state law would still govern. So we would, even if our rules don't look like this after today or, you know, after the first meeting, we would still have to follow state law starting August 16th. So it would functionally be the same. There are a few updates within this that are not state law mandated. Those would not change until it's formally voted on, but the state law changes would be made. So most of this red line would have to apply regardless.
Basically, what's the point of us even bothering to vote? Because it already, I mean, this is what it's going to be. It doesn't matter what we want.
So, good question. I would say sometimes it's easier, you look at the state law is multiple pages, it's a lot of legalese. Sometimes it's easier for us to have local rules to be able to understand them more easily, easier to interpret them in chunks rather than having to understand the entire law. Certainly, we could look at approaching it a different way, but this is just how it's been done for the commission previously. It's similar to, we have city administrative policies. So, for example, there's a law on family and medical leave. We have to follow the law for that, but we also have a local policy that outlines it. So it's just easier for employees to access, easier for employees to understand. There's a few things we have to make sure and clarify that the law requires, but we wouldn't have to outline all of that, but to make it easier for the employees.
The other thing is sometimes the state law just says you will have, you know, the city has to have a subpoena process. It doesn't tell you how you have to administer it, so that's where our local rules come in, right? So our local rules say we're allowing you to do subpoena, here's the process for that, whereas the state law just stops at it's allowed, or you have to have it. And so that's why there is some voting that needs to have, or rule changes that need to happen, is sometimes it's just setting out that procedural aspect of what the state law is mandating. That because state law doesn't try to prescribe, like, every city has to function like this on everything. There are certain things that they allow discretion on, and most of it is at the process level, like, how are you going to enact what we're telling you need to follow? So
I think that's a great point. When we talked about production of exhibits and exchange of exhibits, the law said that the commission has to provide for that, has to provide a procedure for that. The recommendation from staff was 5 working days in advance, at least 5 working days in advance of the hearing. That's where the commission has to decide what you'd prefer. So that's a good clarification. Okay, so next steps, we would request that you vote to suspend Rule 1.5 for this meeting only, for these rules only. If that vote went through, then, or if it didn't, either way, as Attorney Huff said, then the commission to have any additional discussion on the proposed updates, and then we would request a vote to approve the proposed updates effective August 16th, 2025.
Okay, entertain a
Any
motion for
questions?
Suspension of the Rule 1.5.
Motion to approve.
Second,
I'll second.
all those in favor?
Aye.
All right, then a motion approving the proposed updates to Rules 3.3, 3.4, 5, 6, 8, 4.1, and 4.2, effective the 16th of August. Entertain a motion.
I make a motion to approve.
Second? All those in favor?
Aye.
Okay, it's carried.
Thank you.
Asking the commission to approve or updates to minimum qualifications to 3 positions. The first one is rehabilitation specialist, which is a position in our community and economic development department. So if you look further down the page, on page 1 for rehabilitation specialist under qualifications, the first section, we're just making some clarification and language updates to the first paragraph. So right now, it just says that the candidate needs to have graduation from a high school or from high school. We just want to make this with standard language for other positions that we have. So we're saying must possess a high school diploma or GED equivalent. And instead of saying supplement it, we're just going to say the word plus, 2 years of experience. We're keeping all the experience the same, and then adding which provides, again, the knowledge, skills, and abilities necessary to perform the work in this position. Next, we are asking to remove must have experience in preparing bid documents or construction estimates. This actually opens up the candidate pool, and we feel that the minimum qualifications above are a better fit for the position, and if need be, this is something that could be taught. Next up is a national standard, and it is a requirement per HUD. They must have a lead inspector risk assessor certification within 6 months of hire and maintain that throughout duration of employment. If you turn it over to the back side, this is another national standard required by HUD. They must obtain a national standard for the physical inspection of real estate, or what we call Inspire, certification within 6 months of hire. So our current rehabilitation inspectors already have these 2 certifications. We just want to make it clear that it does need to be maintained, and if we ever have a vacancy, it's already in there and it will not delay a recruitment process. And then we're adding that they do need to have a driver's license.
So this is a rehabilitation person. This actually works with people to help them get better.
So not on a personal level. On this position, the city offers programs. So we actually have our urban homestead program, or the city will actually might help finance or finance a project for a home in a particular area. So the resident would submit an application to make these improvements to their home. They would be reviewed by our CED department and then approved, and then we would have this inspector, again, it would be rehabilitation to homes
So
within this.
this is rehabilitation of buildings, not of people.
Correct, yes.
Specifically homes, I believe.
Yes,
Okay.
okay. Then next up, we have our sewer TV technician, which is part of our Public Works Department. Towards the bottom of the page, you're gonna see red line text there, or red text. So we're asking to add a certification where they possess a pipeline assessment certification from NASCO within 90 days of appointment, and then maintain that throughout duration of employment. And then if you flip it over to page 2, so right now it just states that they do need to have a background check. It is a promotional opportunity. However, if we had somebody promote to this position that did not require a physical, We want to make sure that's clear, so it would need to have a background and physical check for the position. And then because it does require a CDL, we want to make sure that candidates are aware that they are part of the random drug and alcohol testing program.
So this is a full-time position where they just operate this camera through the sewers?
Correct.
Really?
If you want more info, I can call.
No, no, that's fine. I mean, it just seems like, wouldn't be that much. Plus, why do they need a camera? Is it that big?
It's the vehicle that they're driving with the camera on it.
Okay.
And then next is our street heavy maintenance worker, which is in the street division of Public Works. If you turn it to page 2, where it says qualifications, really, we are actually just updating the verbiage to make it clear to our candidates what we require for the position. So right now, it does say that you need 2 years of progressively responsible experience in the installation, cleaning, maintenance, and repair of infrastructure, or 1 year of concrete flat work. So concrete is a main function of this position. So right below it, for the wording update, we want to make sure that's first. So we're keeping it as 1 year of concrete flat work experience. Then we're asking for 2 years of experience in roadway construction maintenance work, which I think is a lot easier to understand than the verbiage above. And that is it for our minimum qualifications. There are no questions. Are there any questions?
Can we vote for all of them at once, or?
You can vote to approve items 2, 3, and 4 on the agenda under new business.
Ready for a vote? Okay, I would entertain a motion to approve 2, 3, and 4 as presented.
I make the motion.
Second?
I'll second.
All those in favor?
Aye.
Okay, so carried. Old business we did, right?
Old business is kind of what I mentioned during the presentation. So this update to Rule 1.2 was presented at the July meeting. This is based on the commission's desire to have a public with business section on the agenda. So it was reviewed last month and then for final approval here today.
Okay.
So it's already been implemented, but this is just codifying it in your rules. So I would just request a motion to approve so we can get it.
Discussion? Okay, entertain a motion to approve 1.2.
I'll make the motion.
Second?
Second.
All those in favor?
Aye.
All right, so carried. Certification list.
So first up, we have our Code Enforcement Officer 2 position. It is an entry-level position in our Development and Neighborhood Services Department, and we had our 30-70 split. So candidates do need to have a high school diploma plus 4 years of experience in the building construction trades, home inspection, environmental inspection, public relations, or equivalent combination of training and experience. And then we have the rest of our qualifications, along with our certification. So we did have 52 applicants. 16 of those were qualified and invited to the written exam. 7 did not schedule, 1 did not show, and 1 scored below 70%. That left us with 7 candidates that passed the written exam and were invited to the interview. 4 scored below 70%. So we have 3 candidates that passed the background check and are on the list to be certified today. And then our stats. Next up, we have our lead plant operator, which is a promotional position in the water pollution control plant of Public Works, and our written exam was weighted at 100%. Candidates do need to be certified as an Iowa Grade 2 wastewater treatment plant operator, have 2 years of experience monitoring and controlling equipment in a water or sewage treatment plant, and then have their Class B CDL with air brake endorsement, and then maintain that throughout duration of employment. So we did have 5 applicants. 3 were qualified to the written exam, all 3 passed, and are on the list to be certified today. And then our stats. Next up is our park supervisor. It's a promotional position in our Parks and Rec department, and we had our 30-70 split. Candidates do need a degree in either recreation, turf management, or natural resources. Obtain their Iowa pesticide applicator certification in 1 year, along with their certified pool operator certification in 1 year, and have a valid driver's license. We had 11 applicants, 4 were qualified. Those 4 were invited to the written exam, and they did pass and invited to their interview. 1 did score below 70%, so that leaves us with 3 on the list to be certified. And our stats. And that completes our certification list for today.
Can we approve all 3 at once? Okay. I entertain a motion to approve all the certifications set before us today.
I'll make a motion.
Second?
I'll second.
Okay, all those in favor?
Aye.
All right. Anything else? All right. It was a good meeting. Entertain a motion to adjourn.
I'll make the motion.
Second?
Second.
All those in favor?
Aye.
All right, we are adjourned until September